Now, here is our very popular segment among the immigrant community, that is Legal Discussion, with Mr. Fitzgerald Lewis and Mr. Ali Azhar, attorneys at law from the law office of Lewis and Associates, Falls Church, Virginia.
Namaste viewers, this is Fitzgerald Lewis
and Ali Azhar
from the law offices of Lewis and Associates in Falls Church, Virginia, and you're watching us on Sagarmatha Television program. What are we talking today?
Mr. Lewis, I wanted to talk about something slightly different on this segment. We've had someone who called our office to inquire about a unique situation, and I thought that would pertain to a lot of our viewers for this wonderful program that Ram helps us with. Let's say you have an individual who's a permanent resident and he applies for his family members. Amongst them, you have children which are close to 21 or about to turn 21, something to that effect. And it takes several years for them to obtain their permanent residence for the derivative beneficiaries. Now, what happens if the principal beneficiary becomes a U.S. citizen? And while the applications are pending, does he need to file again? And if he does need to file again, what happens if the children are over 21?
This is a complicated question, so I don't know if you understood it, but let me explain what I understand Ali is asking me.
Okay.
What I understand Ali has just asked me is, let's say that a green card holder files for his wife and children one application, it's called an I-130. 5 years later, that person becomes a citizen. Is that enough for that I-130 for everyone to get their green cards? The answer is no. And the reason is because when you file an I-130, you will generally do it for the spouse as a green card holder, and you just need to file one I-130. And every child under the age of 21 is covered under that application. Now, once you become a citizen, the law requires that each individual must have their own I-130 approved. So we have had situations where a person goes in, files their I-130, hires us later on, and then while the I-130 is approved and he has become a citizen, we have to sometimes file this request to expedite cases so all the family can come in. So the answer is that if you're a citizen, you must file separate I-130s. If you are a green card holder, one I-130 for your spouse will cover all unmarried children under the age of 21. The other thing is just for people who are in that category. If you're a green card holder, currently the wait time is only 4 to 5 months to bring your wife and unmarried children. So it used to be 3, 4, 5 years. That has substantially reduced under the most recent visa bulletin. So please talk to your lawyer or someone so that they can expedite these cases and get your family members in the U.S. Any other issues?
No, Mr. Lewis, I think that's the only question we had. I thought it was pretty interesting for this particular segment. I'm sure this will raise a lot of questions from our viewers, and hopefully we can address them as we go through this wonderful program.
Okay, this is Fitzgerald Lewis
and Ali Azhar
saying goodbye and God bless for now.
Thank you.